In this video, we're going to be talking about post-offense rehabilitation. What does that mean? It means looking at the individual's redeeming qualities after they committed a crime. Every day, I see other lawyers on their YouTube channels or on the television tell the audience that their clients never accept a plea deal. Well, that's a lie. That's advertisement. That's not how reality works. In real life, some cases are good for trial, and some cases are just too much risk and too little reward to take to trial. But regardless how you resolve your case, if you plead guilty, or if you go to trial and lose, you'll be before a judge for sentencing. So I always tell my clients, make sure you're on your best behavior during pretrial release. What does that mean? It means not committing new crimes, not violating your pretrial release conditions, and then be the best example to the judge. Be a good citizen. Volunteer, work a little extra, so when we come to sentencing, we can tell the judge that this is a special person to put in jail or in prison. They have redeeming qualities, and probation or a lower sentence is appropriate. So today we're going to be talking about a Supreme Court case that deals just about that. Talking about post-offense rehabilitation, where the judge sentenced the individual to probation instead of years in prison. If you find yourself in federal court, I urge you to hire an experienced federal attorney that works in federal court every day. One, it helps to have an attorney that knows every single judge in your district. And two, your attorney should know the ins and outs of the federal sentencing guidelines. This book lists every single crime in the federal system and the amount of time an individual should be facing if they get convicted of a certain crime. And your attorney should be able to use the guidelines to your advantage to some degree. For example, if we're dealing with a drug case, it could be the quantity and quality of the drugs where the argument lies. If we're dealing with the transportation of illegal aliens, it could be where were those individuals placed inside the vehicle. And finally, if we're dealing with a gun case, it could be whether the firearms had serial numbers or if they didn't, and which one counts towards the sentence. Now, additionally, there's criminal history to worry about. In the federal system, your criminal history counts. Now, if you don't have any criminal history, that makes it easier. You'll be in the first criminal history category. But if you do, your experienced attorney should be able to argue to the judge that your criminal history is exaggerated and it should not be used or counted completely in calculating the sentence. It is critical to understand the sentencing guidelines in federal court. It allows the client to know the exposure they're facing when they take the case to trial. It also allows them to understand how much time they would be facing when they see the judge for the sentencing hearing. Now, time and time again, I see other attorneys, when I watch them in federal court, fail to deliver at sentencing. Even though they tell the judge that their client deserves less time or probation, they're just not convincing. They're not bringing the best arguments. So I always tell my clients, it is their job to explain to me their past, to show their redeeming qualities to me, and then it becomes my job to convince the judge that those redeeming qualities should be counted in reducing the sentence, or ultimately giving probation sentence. So I know you're here for me to review a Supreme Court case, so let's get at it. Let's talk about Gall versus United States and the facts that are in that case. The case deals with postoffense and pre-indictment rehabilitation, and how the district judge used it in order to sentence the client to probation. Mr. Gall was a student at a university. He joined a conspiracy to distribute ecstasy to other students, but within 7 months, he withdrew from that conspiracy. He has not committed another crime since. He stopped using narcotics himself, graduated from the university, and found a good career. 3.5 years later, he gets indicted with a conspiracy to distribute narcotics in federal court. He accepts responsibility, pleads guilty to the charge, and is facing sentencing before a district judge. Now, the probation department recommends between 30 to 37 months of custody time for this particular case. This is from the guidelines that I've mentioned before. But spoiler alert, the district judge sentences Mr. Gall to 36 months of probation, no prison time. And here's why. Because everything I just mentioned, other than him committing a crime, were all good facts. And additionally, he was a very young person at the time of the offense. He was just a freshman in college. And since then, he has turned the corner. And to add more, he did this pre-indictment. He didn't do it because the government told him, because probation told him to do it, because the court told him to do it. He changed his life around because he wanted a better life for himself. And the court stresses that probation is not a lenient sentence. Instead, he's going to lose substantial freedoms as a result of 36 months probation. Mr. Gall will have to report to probation. He will have to be regularly drug tested. He has to ask for permission from the probation officer where he can work, where he can live. And finally, a harsh sentence is hanging over his head if he fails. The court added that any term of imprisonment would be counter-effective by depriving the society of the contributions by this defendant, who clearly understands the consequences of his criminal conduct and has done everything in his power since to forge a new life. So you might ask, if it's this easy, why are we in the Supreme Court? Well, because the government appealed the sentence, and the circuit court said that when the judge deviates from the sentencing guidelines, gives a harsher or more lenient sentence, there must be extraordinary circumstances that call for such a deviation. Now we get to the Supreme Court, and the Supreme Court says that's not true. There shouldn't be or doesn't have to be extraordinary circumstances. The sentence must be reasonable. And the district judge is in the best position to value the case, to look at the defendant as a human being because he's standing before the judge, rather than the appellate court that's just looking on papers. And because of that, the 36 months probation stands. So here are a couple lessons I want you to take away from this case. First, even if you don't take the case to trial, having a good defense attorney on your side clearly helps. In this case, the attorney was able to bring good facts to light and convince the judge to sentence Mr. Gall to 36 months probation. And even when the case went all the way to the Supreme Court, the sentence stood. Which brings me to the second point. Whenever I get a new client, I tell them that just because you got arrested, it doesn't end your life. Please have hope. Continue pushing forward and changing your life around. The character letters help. I have a couple of videos that talk about character letters, but of course it's your conduct once you get arrested that helps. You don't always get cases where the person changed their life before indictment, but at least once you get arrested, the next period on pretrial release should be an example to the judge of how great of a citizen you are. Volunteer extra, work a little extra, so then I can bring all of those facts to the judge at sentencing. And just a reminder, if you have a good case to trial, take it to trial. And if you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.